And we're live.
All right. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for December 8th of 2025. Brad, go ahead.
Well, everyone, hide your children. Don't let anyone listen to this one. And if there's any minors in the room, please have them leave because this is just blatantly disgusting. And I cannot believe we're even forced to report this. But we're going to go to Baltimore County, where we have a paramedic who is under investigation. We don't know that this is, there's no confirmation, just an investigation, to be clear. But there are reports of, you title them inappropriate behavior. I think that was
I'm
being
being
kind.
polite. I'm
Yeah,
trying to my best to be polite.
yeah. So here's what happens. Apparently, there's OnlyFans, and somebody posted a video on OnlyFans. It was then an anonymous person made a report of what they saw. For those who don't know what OnlyFans is, it's a paid site. I guess I think it's only pornography. I don't know if there's anything else on it. I don't subscribe, but in any event, a paramedic who they've now identified, had posted very sexually explicit and disgusting videos, which were filmed at a fire station while the paramedic was on duty. Now, we'll go back to that in a minute about what policies you might think of having. But the video clips had him self-pleasuring himself. I'm trying not to use words that
Yeah,
may or may not get
that's
us
a good way
banned.
to, I guess,
Yeah.
say it.
And urinating on coworkers' foods and belonging. So I want to say, if that's true, he could go to jail. I mean,
He
that's
should. He
yeah.
should, and he should also get some therapy.
He may get some in jail. But nonetheless, yeah, that's anyway. So it's listen, it's the department's investigating. Again, still under investigation. We don't know. But one thing I want to say is I don't think anyone needs a policy of don't urinate in people's foods and please don't self-pledge yourself, while at the station. But nonetheless, the policy you should have, however, right, and we have done this as one of your policies from must-have policies, is that you should never use department property, whether it's vehicles or the real estate or whatever. You should never use, like the station, you should never use the department property for personal reasons. And this would be personal reasons. So we've reported, I think, on some others who have done calendars, maybe inappropriate calendars, inappropriate videos, not like this inappropriate, but just a little inappropriate, using the trucks. I remember the one with the Hooters women. This was in New York, I think, posing on the vehicles. And is that inappropriate or appropriate? There should be policies on what you can use, turnout gear,
I
and everything
One of
for.
the policies we have is on photo taking and posing, particularly for commercial purposes, and even a calendar for charitable purposes is still for commercial purposes. So anything for commercial purposes where you're going to be making money or selling something such as this, which is again in a different league
Different
than a
world.
okay, but anything for commercial purposes needs to be with permission from the department. And then anything sexually explicit is prohibited. It should absolutely be prohibited. There's so many the sexual misconduct policy, would be addressed here. Social media and digital imagery would both be violated. There's so many policy
Yeah.
violations here.
And nonetheless, how about criminal laws, right? Please
Well,
don't violate criminal laws while on duty or ever.
we're in a society that I feel like we're going in two different directions sometimes where, we want to be open and inclusive and anything goes if that's what, but this exceeds, yeah, this exceeds any bounds. And here's why. Okay, there's a number of different psychological conditions. Okay, and some people say, well, you shouldn't have psychological categories for people that govern sexual expression and all that. And I said, oh, okay, fine, whatever floats your boat is fine. Okay,
Right, right.
but when you do things that hurt other people,
Yeah,
when you harm, now you're talking about either antisocial personality disorder, psychopathic, tendencies, sadistic, like when you actually get gratification
Out of
from
hurting
inflicting
others.
harm on others. Now you're talking about something different. I'm not saying we don't know the facts of what happened in this, but I'm trying to go through my head and say what would cause somebody to engage in this kind of behavior and apparently think it's okay and apparently want to profit from it. And then you have people that apparently enjoy watching this
Well, and
because
go
there
back
must
to
be
what
a
you just
market.
said.
Hmm?
Not only profit, he posted this as proud, right? And tried to earn money from it.
That's
So
what
he
it profit. That's what I
right,
mean. He's
yeah,
profiting from it, you know. But then on the flip side, there's people watching this.
paying to watch it. Paying to
So
watch this.
again, the part of our society that's going in the direction of, and I don't even know what category you put this under, LGBTQ
No,
or
no,
well,
no.
what is queer? You
I-
know, I mean,
But
you know.
I mean, look,
So
Satanists
at any
could
rate,
be,
we,
but
we don't we don't
yeah,
even need to go there with that. The point being, this is different than
this is
that. This is
assault.
different than just a lifestyle choice. Okay,
Right, right,
this is hurting people.
right. This is
And,
assault.
and you know how did our screening mechanisms that we need to have not pick that up in this in a case like this? How does somebody who is willing to inflict that kind of harm on people? I can
In the
see I can see people really with psychological injuries in that fire
Wait,
department.
you just answered the question. As you know, in the police department, you go through psychological evaluation before you're hired.
Well,
In
we
a fire
should.
department, nope.
Well, when I was with Providence, we did. Everybody did.
Really? How
Yeah,
common is that?
absolutely.
I've never seen that.
Oh yeah, oh yeah. No, they absolutely, absolutely.
I got to tell you, I was in a career department for 20 years
Yep,
and
yep,
volunteer. We
yeah.
never had anything like that. I mean, half the departments are lucky if they could pay for a normal physical. I don't mean a BS physical, but I mean a real physical. Most departments can't even afford that and don't even do that. So psychological evaluation.
Oh yeah. No, absolutely, absolutely. So um again, now I do want to say something else about this. And I think the documentation that I saw, and I thank the folks that reached out to me and provided me with some of the information that we had there. But we had an incident in Providence where a firefighter was on a paid detail at a local college, there's several colleges in the city. And we have a paid detail whenever there's going to be a bunch of people in place of public assembly, more than a couple of hundred, you got to have a firefighter detail and so on. So one firefighter on duty at this local, it was this state Rhode Island college, it was college, but he was on duty as the paid fire detail, and you're supposed to walk around. It was for a play. There's a college play, and from what I understand, and the absolute best information that we have, that he walked backstage, and the main actress in the play, he was backstage. She walked off the stage. Now he's supposed to be back there. He's supposed to be making sure there's no exits blocked or no fire hazards or different things. And you don't just take a one position, you go around. So he's backstage, bottom line. She comes off the stage out of view of the public, and she lights up a cigarette. Now, there's no smoking, in a place of public assembly like that.
Yeah,
And so
yeah.
he goes quietly like this, but he goes like this. Okay.
Okay.
And she reports him as making an obscene gesture. Now he's going like this, like he doesn't want to make noise, but he said you can't be smoking. He doesn't want to say it because he's right
Right.
near.
Right.
Okay.
Right.
Okay, so fine. Okay. So now the department receives the complaint that he made an obscene gesture and everything. They start investigating. The rumors going around were that he sexually assaulted her. You see what I'm saying? So
Yeah.
the
Yeah.
potential for somebody says, hey, he's in trouble. They made an accusation. Then the next time it gets embellished. Then the next time it gets embellished. And the next time it gets embellished. And now throughout the stations, this guy's under investigation for sexual assault. Well, how did this turn
Yeah.
into, you know?
Right.
So again, I'm always mindful of that. I was a chief at the time when this happened, and I watched how the rumors got spread. And you know how firefighters love to take a story and embellish on it, embellish.
No, no,
Well,
never
it
happened.
happens. It happens. Okay, but and then it's very hard to unpack once the suitcase has exploded, it's very hard to
Yeah,
put it all
yeah.
back together again. Okay, but bottom line is, I'm mindful of that type of scenario. Um, I'm not confident that that's what happened here, but sometimes things do get blown out of proportion, and it's not what it initially seemed. Okay,
Right.
so but if the facts that I have there that are publicly reported through news media outlets are accurate, this is I've got some ridiculously obscene cases in my database, but this one is right up there.
Yeah. And don't forget the anonymous caller, presuming they're not affiliated with the fire department, and maybe they are, who knows, right? But the anonymous reporter of this noticed that it was at the fire station. So clearly there's something in the video that, right, whether
Yeah.
it's a person's uniform or whether it says, Baltimore City or whatever it says, clearly they figured out who to report it to and where this happened.
Yeah.
So, okay, well, enough of that.
Yeah, enough of that.
Yeah,
Let's get on
Jesus.
to the normal
Yeah, the
problems.
normal weird things, right? Yeah, no. So let's go to Chicago. So we have a federal court who is dismissed, kicked out a lawsuit. I'm going to summarize not even the facts, but the holding, and then we can get into the facts. But the facts are so long and in some sense so complicated. But let me at least jump to the end, which is what the court says, and I think this is really important. One of the things the court holds is that everyone should know the Fourth Amendment, right, which is a search and seizure, and it's not just taking your property, it could be taking you, but forcing a firefighter to undergo psychological testing and evaluation, as well as spirometry testing and physicals, is not a Fourth Amendment issue. It's not a search or a seizure, and I think that's a big holding. I don't want to get lost in the facts. I mean, in short, I guess the facts, if we want to summarize them, were that they became concerned about an employee for certain reasons, interesting reasons, and then had a home visit with her to interview her, and ordered some, this psychological testing. And, she sues one of the many reasons, saying, well, you violated my Fourth Amendment rights. And I like it. I'm glad the court held this. This is a big deal. I don't know if it was the first time. I didn't check the citations in the
I
decision.
didn't jeopardize it at all. But
But that's a big holding. I agree with it, of course, but it's not a mind-blowing holding. But the fact that ordering you to go somewhere, right? And think about how she would say it. You ordered me to take myself or be brought somewhere else, which is a seizure, and be mentally searched, right? Evaluated. It has some merit when that's how I think of it.
yeah,
It has some merit to it. And I'm glad the court says, nope, no search and seizure, and it violates no other law that they could find.
yeah.
Um,
I hadn't really focused so much on the psychological part of it. I was thinking more on the PFT because he also talked about whether or not a PFT is a search, and the judge said the PFT was a search.
I kind
So,
of get that, but I kind of don't.
well,
But it's
the blood test. Courts have said
blood
historically,
tests.
blood tests,
Yes.
breathing, what do you call it, the
The
breathalyzer.
breathalyzer. Yep.
Those are all Fourth Amendment searches. Okay.
Yep.
Medical exams, I guess when it's compulsory, yeah, I don't know.
Well, but you could think like when you're taking blood and you're diagnosing you physically extract blood, that's one thing.
Mhm.
But to capture breath, you're not extracting it, you're capturing breath, I would say is not really a search. It's definitely not a seizure. You're not seizing their blood. It's not a seizure. It could be a search because you're then evaluating it. But here's the way I would have thought this comes out is that when you breathe in the air, it's now public domain, right?
Yeah,
Nothing in the public domain is necessarily protected by a constitutional right.
right. But now the PFTs, you're breathing at a certain rate in a way that
Into
they're
something.
describing and into a certain thing. So I don't know. It's an interesting
Yeah.
issue. Um,
But she, and she refused to do certain tests. She refused drug testing here, but generally a refusal to do a mandatory physical evaluation is cause for termination and doesn't violate.
Insubordination, yeah.
Yeah, it's insubordination, and it doesn't violate anything, any right whatsoever. And the court even says, right, there's no law we can find this would violate, which is probably why they went to the Fourth Amendment. I don't know. It's an interesting case. It's so long. But it is an interesting case. But it gets dismissed, and that's what I took away. That the psychological evaluations are not a seizure, even if you're required to go to it, and it's not a search.
Well, let's think about it, because the Fifth Amendment applies to testimony.
Yep.
It's a testimonial privilege, and that often comes up with Garrity. If I'm ordered to give a blood sample, isn't I giving evidence against myself, right? And I've heard firefighters raise that question, that you're forcing me to give up my right to remain silent. No, the right to remain silent is a testimonial
Right.
privilege, and the Fourth Amendment is really for evidence.
Right.
And so when you're doing a psychological exam, might the Fifth Amendment be an issue more so than
what you're asked? Depending what you're asked, it could be.
right? You see what I'm saying? So whenever I think of, to me, you gotta separate, like, our world, and this is so inculcated in us as attorneys that we don't even think about it.
Yep.
But the world is divided into two things: testimony, which comes from a witness,
Yep.
and physical evidence. Okay. And when you're dealing with a blood test, it's not testimonial, it's physical evidence, it's Fourth Amendment.
Yep.
When you're dealing with testimony, you're dealing with the Fifth Amendment and the right to remain silent. So they're different. And so the psychological exam, unlike a medical exam, a psychological exam to me would be testimonial.
Of course, because think about the question. How do you feel about pain, causing pain in others, right? That would be a general, I like it, I don't like it.
Yeah.
How do you feel about the pain you caused others when you did this? Oh, wait a minute. That's investigatory, right? That's clearly Fifth Amendment. So depending on the question.
Fifth Amendment than Fourth Amendment,
Yeah.
So
Yeah.
I'm not saying the attorneys maybe should have made a different argument, but it just seems to me, whenever my mind goes immediately to physical evidence and testimonial evidence,
Agreed.
Fourth Amendment is physical evidence, Fifth Amendment is testimonial. So
yeah, fine line, I guess. Okay. Let's go to a very unique case, not confusing at all. Let's go to Missouri. I love this case because it is so off the wall, and I can't imagine you have the word speed bumps in your database, but let's see.
No.
So we have a fire protection district. So a fire entity is suing the city because the city is closing streets and installing speed bumps, which the department is alleging ultimately is going to delay responses and cause damage to their vehicles. I think it's a losing case, but it's a very interesting. I've never seen anything like this. So
I will tell you this. This is a separate fire district from the municipality, but I can tell you there's fire departments that are upset with their city.
Oh, I'm sure.
You can't really sue because
Right.
it's another city agency. You got one city agency that's upset with another city agency,
Right.
but this frustration over some of this stuff, is happening across the country.
I get it. And the opposite side of this is, look, speed bumps have one purpose: to slow down people's speed. And if I was on the city side, first, obviously, they're going to argue immunity. They're going to argue discretion. They're going to argue health safety, right? That's their mission, to protect the public. And the greater good is to slow people down so they don't cause an accident to which the fire department needs to respond, right? That's how I would be responding to this. But the other argument I thought of, because I always like to read these and think, how would I, argue it back? I would say to the fire department, well, you generally don't need to speed. And in these neighborhoods, it's unsafe to speed. So you shouldn't be speeding. We don't want you speeding. So we're controlling, yes, we're even controlling your speed to incidents, because in these areas, and I don't know what the areas are. Maybe there are areas with children, right? Maybe there are school zones. Maybe they're high traffic areas where speeding would be unreasonable. And so maybe they say, you're right. That's exactly what we're doing. We don't want you to speed.
Well, as I read it, it's not simply that they can't have the speed bumps. It's that you've got to include us in the process of
The plan.
reaching the decision. And I know, from my experience, you got four roads going in the same direction parallel. Maybe one of them, through a negotiation, one of them is not going to have the speed bumps. Okay, so that the fire apparatus can get down that street to get to the next, neighborhood without having to go. And then certainly on those streets with the speed bumps, then you'd have, or I think they call them traffic calming devices now, because it's more than just bumps. Some of them are traffic circles with high curbs and different, making it difficult for larger apparatus to get down there. And you can have a sign that says commercial vehicles prohibited. Well, that's going to prohibit delivery trucks and commercial vehicles, but we still have to get our apparatus down there. And so that's why I think our input has got to be mandatory. And I think that's really at the the basis of the allegations here, is that you've got to include us in the process. You can't just exclude us
Right.
and only be concerned about the.
And I know at least in New York, the maintenance or the design of streets is not an environmental factor. The location of them is, but the design is an engineering discussion, which is generally exempt from environmental evaluation. There could be, right, runoff, and I mean, there's a lot of environmental factors, but typically speed bumps wouldn't be an environmental factor. And I say that because with environmental factors, you need public input and public hearing, at least in New York.
Oh, yeah.
So yeah, there's a whole thing called the State Environmental Quality Review Act, SEEKR, and it's almost anything you do, you have to evaluate the environmental impact.
Let's
Even
let's let's do a hypo. We'll go 5 years into the future after all these calming devices are in place and someone passes away because the fire department couldn't get there in a reasonable period of time.
no
Uh,
lawsuit.
yeah.
That's like saying, well, you installed a stop sign. If we didn't have a stop sign, we could have gone through it. Why is it any different than a stop sign? Why is it any different than a school zone? Why is it? It's not. And I just, there's
Very,
no way.
very difficult. Yeah.
Yeah, I just, this is not going to succeed. And frankly, with ambulance, there's so many cases that show with EMS response that driving faster, so many studies that show that driving faster doesn't have any real impact on any significant number of lives. Obviously, in the fire side, we know that not necessarily to be true, but who knows? Okay, I hate this case. You picked out, this is a really interesting week because there's nothing normal here. This is like the nothing normal
Well, I
week.
guess I do pick them, but they kind of pick themselves.
Yeah, they definitely do. This one just pisses me off, not at the driver who I'll talk about, but at the lawyer who's filing this. So we have a second wrongful death suit. You and I covered, I think, part of this before, if I recall. We're in Tulsa, and we have an accident where a number of kids died in the car. This lawsuit is being brought by the driver of the car, which had the victims, the children in the car. Now, normally you say, great, sure, yeah, they should, right? You killed her kids and others. She was found to be high on cocaine and marijuana at the time. The driver of the vehicle was found to be high on cocaine and marijuana at the time. So presumably clearly impaired, and she's the one suing because she had a collision, right, with a fire truck. The fire truck, and I'm going to tell you what she did. I'll tell them what she did, and what she allegedly thought. She thought she could beat a fire truck out in a turn. But the whole point of driver laws is when you see the lights and sirens, you pull over. You don't try to beat them out of their maneuver. You don't try to guess what they're doing and outmaneuver them. And I'm sure she had the perfect, if it's true that she was high on cocaine and marijuana, then I'm not so sure her judgment was probably in the best place about how to beat the engine or make its turn. But this is infuriating, not at her, that a lawyer would file this case. I want to know, what am I missing?
All right. Well, let's kind of take just kind of unpack what you just said. Okay, because I agree with you on one level. Okay, certainly the emotional level here, the fairness part of this. speaks to what is going on. Why would an attorney take a case like this? Why would someone bring a case like this? This is ridiculous. It's unfair. They should lose. Okay, so let's kind of put that on a shelf. Okay, there's an economic issue here, and she is, I believe, based on the circumstances, either judgment proof or she is going to be judgment proof. She's paralyzed. Okay. And it appears that that condition is not going to be reversed in the near future. Okay. So she's paralyzed. Okay. Who pays for someone who is destitute and paralyzed and is going to need help for the rest of their life?
The
Who's
state, the
okay?
state and federal
So
government
the
doesn't care.
taxpayers,
They'll do it. Right.
the taxpayers are going to be on the hook for this. Okay. And so, and she is probably, it's been over a year, almost a year, I guess. Yeah. Well, it happened in, yeah, over a year now.
Yeah.
Um, she's probably got over 1 million, 2 million, 3 million in medical bills already incurred that she's not going to be able to pay, that are going to have to be
And
paid
yet she only seeks 75,000.
from them. Okay.
Right.
So, and she's going to need lifetime care and all the other things that somebody who's paralyzed is going to say. So, if we put the fairness issue on the side, okay, in order to recover from someone, we have the thing called comparative negligence. And so, comparative negligence looks at who was at fault for something happening based on a percentage. And if in some jurisdictions, now some jurisdictions say you've got to be 50 or 51% in order to be able to recover, or the other person's got to be 50.
Right.
But others say no, it's a 100% scale, and you could be 99% at fault for an
Cover their
accident.
1%.
But you're still entitled to recover the 1%. Okay. So what's that got to do with this? Well, there's an economic issue here in terms of who's going to pay her medical bills, who's going to pay, who's going to get her maybe a van with a wheelchair lift or whatever, or even buy a wheelchair or whatever it may be. Okay. So there's an economic issue that needs to be separated from the fairness and the righteousness of what she's doing, that I think is probably at the heart of this. Now, when I was reading it, I was thinking, I wonder if the hospitals may have hired the attorney to try to recoup some of their, because certainly Medicare is going to pay some, or Medicaid, whatever federal program or whatever, but the hospitals are going to eat quite a bit of this cost.
Right.
And so might they be the ones, through almost like a subrogation type of theory, that are bringing this act? So that's where my mind
Interesting thought.
went
And
into this.
just so people know, so because I want to go back and really emphasize what you said, right?
Mhm.
So if in this state, I don't know, if in the state you could recover if, right? Okay, so I was 99%, but the fire department was 1%. Fine, give me the 1% of $1 million, right? I'll take it. So if that was the case, if that's the law, fine. The opposite to that, and this isn't in every state too, it's a basic negligence tort principle. It's called the last chance doctrine. Whoever had the last chance to avoid the accident, right? And if the person suing was the one who had the last chance to avoid the accident, which she would have because she made the turn. I could argue it the other way, which I will in a minute, but then she can't recover, right? If you had the last chance. Some might argue, well, if you were going in appropriate speed and driving with due regard for the safety of others, as they argue, then I would have been able to made the turn, right? And this comes up a lot. I don't know how the cases fall in every state, but this comes up a lot when somebody said, well, I stopped at the stop sign. I saw the vehicle coming who didn't have a stop sign, but it was a 30-mile-an-hour speed limit, so I assumed that at 30 miles an hour, I would easily make it across the street. As it turned out, the person was going 60 miles an hour, and my judgment was wrong. And they fault normally both parties. I can't say in every state, but both parties bear some comparative fault.
And that's going to be a jury question. What
Jury
percent?
question.
60-40, 50-50, 75-25?
And getting to a jury cost a couple $100,000 of litigation, discovery, and so maybe the attorney's being smart and saying, I can get you something for nuisance damages, and if you only want 75 grand, we could probably get that here.
Yeah.
Who knows? It's lawyering at the expense of others.
Yeah, it is. But I think, this is not a situation where she's down on a beach down in the Caribbean, drinking pina coladas and having an attorney,
No.
chase a frivolous case. That this is somebody whose, life is, and she can't blame anybody else. She really can't. But she's paralyzed. There's millions and millions of dollars worth of expenses that she's got. She's lost children and so on and so
Yep.
yeah.
Yep. No question. Okay. So for is it our last case? We've
Yeah.
seen a number of these. We've seen a number of these. I call them rekindling cases. This is not new, but they always bother me. There's no look. We have an insurance company in Illinois suing a fire department over a restaurant fire, and the fire was believed to be out, and it quote unquote rekindled. Now, every fire instructor, every firefighter should know there's no such thing as rekindling, right? There's no spontaneous combustion. So that word rekindled, I don't know why we use it. It was still on fire and it heated to the point of combustion, whatever. In any event, just so everyone understands my belief, look, I believe if you do good overhaul, you still could miss something. You can strip at right. And when we're doing overhaul at a fire, in the back of our mind, we should have two things. One, don't overhaul too much because we don't want to destroy evidence of why the fire started. Let's get the inspectors in there, right? But two, let's leave something to be saved if there's something to be saved. Let's not pull every ceiling for it, right? So what I was always taught, what I always did is pull it to 2 feet past the burn, right? And find the end of the burn, go 2 feet past it, stop there. Now, I don't know what they did, but this is the lawsuit, right? The lawsuit basically alleges you believe the fire was out and it was then a total loss afterwards. So I don't know how you find blame. They're going to have to go back and find where it quote unquote rekindled. I don't even know if that's possible anymore.
Well, I think the investigators, depending, but to me, there's always a factual question. Did the person who said it the first time come back and said it again?
Yeah.
Okay, so or if it was an electrical fire, did the thing that caused the fire in the first place now, if we didn't terminate the electricity,
Well, that would be a good lawsuit, right? You failed to turn off the
and we should be,
electricity.
yeah. But I've gone to relatively small fires, certainly something that is substantial that's affected the wiring. We're going to terminate service to the entire property. But again, you don't know all the details here, but I can tell you, I'm going to knock on wood. I hate to even say it. Chief Arona's never had a rekindle.
I've
Okay.
never either, but I've been to a lot
So
of them.
I'm knocking on wood as I say that because, this
We're not
is,
casting stones to the fire
it's a
department.
very humbling job that we do.
Yeah.
And, it has a way of coming back and haunting you. So that's why I even hesitate to say that. But the bottom line is, things can happen that are beyond our control. And that was what you just said about, you gotta pull the ceilings, open the walls back to clean wood. And that's, one of the things. And then the other thing that I remember as a young firefighter, soak the shit out of it. Soak the
Yeah.
shit out of it. Soak the
Yeah.
shit out of it. What
Yeah.
about water damage? Soak the shit out of it.
Right. Not our issue, right?
Yeah,
Is water damage.
so learning more about building, because when I first became a firefighter, I didn't have any, building experience. And then as you work part-time with this guy as a carpenter, and I ended up building my own houses, you start to learn about things. You realize once you apply water to a room, the whole room is going to have all the plaster,
Yeah.
all of the
Yeah.
blue board and everything. It's all going to have to go anyway.
And what do you think's in the water that we're putting
So,
on it? We're not
yeah,
using
so
filtered water.
yeah, so it's all going to have to just for the mold issue and all the other things. So
Right.
you might as well open it up,
Right.
and the charred wood and stuff that's all going to have to come off. And we had one chief. He's actually a real estate agent, really good guy, good chief. But when I was a young firefighter, but you could tell when he had a fire because there wasn't a roof board left on it. He was not
Never
going to
had
have
a
a
rekindle.
window. And you go by, you go down the neighborhood that I worked in was a pretty busy neighborhood. But I'd be coming into work and say, "Oh, there's one of Chief Quirk's fires." All you had was the rafters. That was it. Everything
Right.
else had been stripped off. Because that's what he insisted on it.
Right.
But he was he had a very lucrative part-time. He was really a business, but a real estate. He's a real estate agent, and he knew. I mean, he knew just from his experience that once you have a relatively small fire, I mean, not a mattress fire, but
Not a
something.
kitchen fire, right?
Yeah.
But yeah,
But
yeah.
once it starts burning the structure, I mean, there's going to be the insurance company's going to come in and they're going to have to strip it all anyway. And why take the chance?
Right. Look, my daughter, just gets her first home. She does the wash for the first time. There was apparently some homeowner left a ball in the sewer line or in the drain line, and her whole basement's flooded with feet of water. Feet of water, right? And that just happened in a short amount of time. Imagine what flowing 200, 300, 400 gallons a minute does.
It
And it's
happens.
gutted. It's good. Yeah, it happened. Right. And I mean, she has to gut her whole, fortunately it was in the basement, but has to gut the whole thing. So, I mean, there's just, anyway, so I'm not gonna talk about overhaul and what I think people should do, but it is a risk of loss issue. Would you rather damage every single home unnecessarily to the point of a total gut job, or would you want the one house to burn down? You know what an insurance company would say? Let the one house burn down again, and let's not damage every other house you go
Well,
to on the
they're
chance
going
of
to
a
go both
rekindle.
ways because if you do too much overhaul damage, they sue you for that. But I do want to, while we're waiting or while we're on here, I do want to just do an analysis here and see how many subrogation cases I have in my database because I
And
don't
I
want
know
to.
we've covered one or two of these.
Yeah, but it's not what I thought. I really thought
There'd be
that
more.
we'd see a lot more. So 28. I've got 14,195 cases, 28 subrogation cases.
But
So,
28 that resulted in a lawsuit,
well,
right?
yes, 28 that result in a lawsuit. But again, I've got somewhere around 700 sexual harassment cases.
Yeah, yeah, yeah.
Okay.
Yeah.
And I got 28 subrogation cases. So
Right.
what's a bigger concern
Oh,
for us? You
yeah.
know, so
Harassment.
we want to keep it in perspective.
No
So
question. No question. But look, I feel badly. The last point we got to make on the legal issue is the question of immunity. And do you have immunity on how you fought this fire? And I'm thinking in most cases it should be the willful wanton standard, right? If there's a public immunity doctrine in that state, but it shouldn't be negligence.
no,
And here's the thing: if you've cut back, if you've done overhaul, you may be negligent because you didn't do it well enough, but you're not reckless. You didn't ignore conscious. Yes, we did overhaul. We consciously tried not to destroy the whole building, or we consciously stopped where we thought it was. Not like we walked away after putting water on it. So let's go home. We don't see any fire. I have a hard time believing that some immunity doctrine is not going to prevent these anyway. And maybe that's why we don't have so many of those suits, because we
yeah,
certainly have a lot more rekindles than that.
right.
And if there
Well,
was liability,
absolutely. Well, we don't have any rekindles, but
right?
um,
Yeah, yeah,
it was a second fire at the same location.
exactly, exactly. Well, like you said, it could have been the
It wasn't a
arsonist,
rekindle.
right?
But but
Anyway, so that's it.
but
That's
that's
it.
20, but that's 28 cases,
Right,
now all of which were successful. In fact, I don't have accurate information on what percentage prevailed, and because when
right,
somebody settles a case, you don't know if it was on
right,
merits or just, the cost of litigation. So,
right. I'd be moving to dismiss on immunity any day. Certainly in a lot of the states where you have the public doctrine. So, okay, that's it for this week.
all right, well, that's it.
Really screwed
And
up week. I don't want to do this. Can we go back to harassment and negligence and anything normal other than peeing in somebody's food? Jesus.
all righty then. On that note, that'll do it for another edition of Fire Law Roundup. We'll see you all next week.